Well, welcome. I'm Mark Mix, president of the National Right to Work Legal Defense Foundation, and from time to time we like to give you some updates on our work here at the foundation. And while this update's not going to be as cheerful as ones in the past, we've got some important things to talk about. And today I'm pleased to once again have Glenn Taubman, one of our senior attorneys here at the National Right to Work Legal Defense Foundation. Glenn's been with us for getting close to about 40 years. We got him when he was fresh out of college, I think, and he may have done a few other things, but that was they weren't very important considering to what he's doing now. And Glenn is our expert on National Labor Relations Board activities, and boy, oh boy, we've got a case to talk about, and we've got lots of things to talk about when it comes to the National Labor Relations Board and what's happened over the last 100 days. So, Glenn, first of all, welcome back. We've done these before, and you've been very helpful in trying to inform our supporters and those that follow our work about what we're up to. And I want to talk specifically about some actions of the National Labor Relations Board recently, since the inauguration of President Biden. And the things that we were interested started about 23 minutes into his administration, with the firing of the general counsel, and now basically putting an acting general counsel in who is really focused on our work. And let's start out by talking about the Mount Air case. If you can just give a little background on this case, where we were representing 800 employees at a poultry farm in Delaware, and how we started this case under the Trump National Labor Relations Board, under his administration, and then the moment we transitioned to Biden, lots of bad things started happening. So why don't you talk to us a little bit about that case?
Sure. That's a very important case that we have here. So Mount Air Farms is a poultry processing plant, 800 workers there, and these workers filed a petition to decertify the union. After many years under the union's representation and being forced to pay dues, these employees did not want to be represented anymore. So they filed this petition back in 2020, and of course the union pulled out every stop to try to stop the petition from moving forward, to try to stop them from having an election. And the regional director, the first level of the NLRB bureaucracy, who reviewed the petition, said it could go forward in spite of the fact that there was an existing contract, because he found that the union security clause, the forced dues clause, was illegal, that it didn't give proper notice to these employees. So he allowed the election to go forward. The union appealed, and we were representing the lead petitioner, Mr. Oscar Cruz Sosa. And the union said, well, this election shouldn't go forward because of this contract bar. And we said, if you are going to review this petition, the union's appeal, you should reject the contract bar. And that is big, because the contract bar is one of these doctrines that's been around for decades and decades that prevents employees from decertifying. So the NLRB accepted review of this case and said they would review the contract bar, and they threw the case open for nationwide amicus briefing. In the interim, these employees actually voted. The election was held, and 800 workers actually voted, but their ballots were never counted. Fast forward to the present day, we have the election. There's now the Biden people that are obviously ruling the roost, and the Trump board, or what remained of the Trump board, said, we're going to drop this case. We're not going to overrule the contract bar. We're going to keep it in place. And in effect, we're going to throw out the ballots of 800 workers.
Yeah, Glenn, and it's important to recognize that the contract bar is not part of the statute. This is a created precedent by board action over a long period of time that basically said, initially, well, there was no contract bar initially, under the statute. Then they said it was 1 year. Then they said it was 2 years. And now it's this 3-year contract bar where literally workers can't get out of a union. So let's say you sign a contract, and the next day you find out that your union official is corrupt. They've been embezzling money. They've done all kinds of untoward things, like the United Auto Workers Union has, 11 executives either in jail or on their way to jail today as we tape this. It's amazing. But you can't have a decertification election to get the union out for up to 3 years under this contract bar precedent that was established. And so while we were defending these employees and their right to have a decertification election because of unlawful language in the contract, the NLRB says, we'll take a look at the whole thing. And not only do they not make a decision on the contract bar, leave it intact, but then they said that the vote that these workers had already, the votes that they'd already cast would be destroyed.
Correct, correct. And you bring up a very important point, Mark, and that is the whole National Labor Relations Act has been skewed over these 80 years by bureaucrats that create all of these blocks and bars and other policies that aren't in the statute. They're found nowhere in the statute, but they sit around and they say, how can we keep union bosses in power? How can we prevent employees from decertifying? You know, there's no bars on bringing a union in. None of these blocking charge and none of these bar policies apply to bringing a union in. They only apply to bringing a union out. And this is really what the problem is, that you have an agency that has been overtaken by 80 years of bureaucrats that are really serving big unions and big companies, and the employees themselves get lost in all of this, and their rights just don't exist in any of this.
Yeah, and that's really crucial, and that's kind of the role that the foundation plays, and Glenn and the rest of our 20 other lawyers doing work, not all of them on National Labor Relations Board work, but exercising legal services to employees who've had their rights violated by compulsory unionism. And I can think of no other example where, you know, we've talked about over the last couple months about election law and about letting everyone vote. But yet, when it comes to labor policy, 800 workers at this poultry plant in Delaware actually cast votes, and then the votes were just thrown away into the trash can. They weren't counted because of this wrinkle in American labor policy, and that's why the foundation's work is so important. Glenn, you know, another thing, not to flatter you, but it's interesting, when the new general counsel came in, when Biden fired the general counsel 23 minutes into his administration, and then fired the replacement general counsel the very next day, and then went to Chicago and got this regional director to come back and be the acting general counsel, he issued a memorandum shortly after he got to Washington, withdrawing memorandums that the previous general counsel had written. And I think, if I counted correctly, there were 9 memos that the acting general counsel cited that they wanted withdrawn and brought back to Washington. And I think the total now is 5 of those 9 cases were your cases, or cases that we at the foundation were involved in.
Right. Well, that's a perfect example of how sort of the bureaucracy takes over this statute, which is supposed to exist, at least on paper, it's supposed to exist to protect employee rights. And yet the bureaucrats and the bureaucracy take over. And in this case, it's very egregious. No general counsel had ever been fired in the 80-year history of this agency. But President Biden came in and in 23 minutes fired Peter Robb, a general counsel who, for the first time in my career, was a general counsel who actually cared about individual employee rights. He issued numerous guidance memos, which are very important. It controls how the whole bureaucracy runs. He issued numerous guidance memos related to our cases and our issues, to allow employees not to fund union lobbying, to allow employees to intervene in cases that dealt with their decertification petitions, to strengthen the duty of fair representation to make sure union bosses were responsible to these workers. He put all of these memos in place, and within days, the Biden-installed acting general counsel withdrew all of them. And as Mark says, not to pat us on the back, at least half of those guidance memos directly arose out of our cases.
Yeah, Glenn, and you know, I remember over the last couple of years, as you and I get together, sometimes I go ask Glenn for my my legal counsel when it comes to things that I should be talking about and things that we're doing, and he explains the complications of labor law to me very often, quite often. But I remember just kind of the feeling of wow, we're really making great progress on behalf of employees and employee rights, taking on, as Glenn said, big business and big labor. And, you know, it's been frustrating to watch over these last 100 days how the Biden administration and their nominees and the people they're selecting to run this bureaucracy once again have gone back to this focus of big business, not even big business at this point, but big labor. Everything they're talking about is empowering union officials and does nothing for the individual worker.
Right. Absolutely. So when it comes to these blocks and bars, again, it's to keep incumbent unions in power and to prevent employees from having elections. When it comes to forced dues issues, can an employee revoke a checkoff? Can an employee resign? These are individual rights that employees have. And these people sit around all day long now, and as they take the reins of this agency and they say, how can we prevent these employees from doing these things? And it really is awful. We had been making fantastic progress, and it is a little sad now to watch the progress get unraveled so quickly by this administration.
Well, the good news is that Glenn's going to get up and come to work tomorrow morning, and so am I, and we're going to continue to fight. These are not extraordinary days in the sense of where we are at Right to Work. We've been through these types of environments before. We've kept fighting for workers. We've kept fighting on their behalf, not only on the legislative front, passing Right to Work laws and defending those Right to Work laws that are in place, but on the litigation side, helping individual employees stand up for their rights in America's workplace. And this work's only possible, and the fact that Glenn can come in tomorrow and I can come in tomorrow is only possible because we have lots of people across the country that believe the same way we do, that the individual should have a choice on whether or not to support a private organization. It shouldn't be compelled, it shouldn't be forced. And we'll keep fighting for that, even during these relatively dark days that we're experiencing right now under the new administration and under this new bureaucracy at the National Labor Relations Board. We promise to keep fighting on behalf of individual workers and the American workplace. So thanks for the opportunity to bring this little snippet to you, and thanks for your support for our work. We appreciate it. And Glenn, make sure you come in tomorrow, because I said you would.
We will be here, and we will continue the fight. I've been here for 37 years or 38 years, and I'll continue. I don't know if it'll be another 38, but I'll continue.
Thanks, Glenn. Appreciate you being here, and thanks for the opportunity to come to you as well.